I get asked sometimes, well, Chad, I just had my injury. I just had a car crash, or I just fell down at a grocery store or something. Don't I have years and years to do anything with the law? I mean, don't I have a long statute of limitations, couple years at least? Well, the answer to that question is yes and no. While I could show you in the law books that it's a 2-year statute of limitations, in other words, a lawsuit would have to be filed within 2 years of falling down on somebody's premises, and while it would be 3 years to bring a claim against a driver who might have caused an injury on the road, the time that the law provides to do a whole bunch of other things that have to be accomplished before you file a lawsuit, those run much shorter than those time periods. There are a whole lot of obstacles that the law puts in the way of an injured person's claim, and that oftentimes those things need to be done, and if you don't do those things well within the statute of limitations, you may have very little or no claim left when you get to your statute of limitations. Here's an example. If anything that your injury has to do with, if any part of your injury has anything to do with a state or county or municipal location, or involves any person from the state, county, or municipality that may have been involved in it, there's a certain document you have to file telling the city, state, or county of your intentions to bring a claim. That needs to be done as short as 180 days after your injury. If you don't do that, but then think you have 2 or 3 years, you're going to have an unfortunate awakening when you realize that your claim is gone because you didn't file this notice within 180 days. Next, you might think you have 3 years, and you do, to bring a claim against a drunk driver who hits you. But a lot of times drunk drivers get drunk in bars. And to bring a claim called a dram shop claim, you actually only have a 1-year statute of limitations. Now, if you think the liquor industry might have been behind that, I think you're probably right. Because a drunk who is being prosecuted in a criminal case has a Fifth Amendment right to stay silent, and almost always will. So oftentimes it won't be until the criminal case is resolved, which can be 6 months, 8 months, 10 months after a DUI accident, that the drunk driver would ever be required to say where he was drinking, or if he even was drinking. He doesn't even have to say anything during the entire pendency of the criminal case. So follow this logic. You can't get the drunk to talk until after the criminal process is done, and then you only have 1 year in the event that it truly is a bar that got this man visibly intoxicated and put him on the road, and you only have 1 year to bring that claim. So you have to have your ducks in a row far in advance of that 1 year, or even less than that 1 year time period, to be ready to basically pounce on that drunk driver as soon as his rights to stay quiet through the Fifth Amendment go away. So the idea that you have years and years and years almost never is the case. You almost always have a whole bunch of things that need to be done. And if you don't do them and you wait to the last minute, you're going to be sorry. Our law firm can talk to you specifically about your case and what kind of level of urgency you've got going in your matters. But the time to think about this stuff is right now.